I just want to welcome everybody. It's a couple of minutes before 7, and we have quite a few people joining us. And so uh, we'll start just a couple of minutes after 7 to give everybody a chance to join. But uh, I look forward to presenting hopefully some good information. Uh, and the At the end, I'll open it up to questions because it is a webinar and not a Zoom call directly. It'll be kind of just one-on-one conversations of questions at the end. Uh, and so hope everybody's doing well. I uh, I did a earlier webinar for nursing home administrators today, and so you're my second chance at this. This one's different than theirs because of this one's going to be kind of giving a little bit more basic information and some planning opportunities. And with that, I think it's right at about 7 o'clock. And so I am ready to get started. Um, I very just briefly, I think most of you should know who I am. I think most of you are going to be clients of our firm, but my name is Jim Roberts. I am an attorney. I've been an attorney now for just shy of 45 years. And during that time period, I've helped about 11,000 families avoid probate, reduce taxes, eliminate family fighting, a lot of complications. If there's something that I do differently than most attorneys is that I jokingly refer to myself as a frustrated kindergarten teacher, and that I try to make things complicated that are complicated and make it simple enough so that people without a legal degree can understand it. Uh, I wish I could tell you that at the end of today's workshop or whatever, this webinar, that you're going to understand Medi-Cal, but Medi-Cal is really one of the more technical areas. I believe that I understand it. Now it's a question of seeing if I can't communicate it to others. And so what's going on is it's called Medi-Cal planning before it's too late, and protect your home, your savings, and your eligibility before December 31st, 2025. And it'll make more sense as we go along. Uh, and so to, as most of you know, right now there's 3 attorneys in our firm. Myself, Holly's been with me for 13 years. Shayla's now been with me for approaching 2 years. Um, that the main thing I wanted to bring out from here is our mission is living the world a better place, one family at a time. And the whole part of this presentation tonight is that there's so much to know about estate planning and how the laws change or whatever. And for some of you that at the end of this, you're going to say, well, this was interesting, but it didn't apply to me, or I don't need to worry about it. And that's a good situation. But it's better to know and not need it than to need it and not know about it. And that we're basically trying to help families with as much of their estate planning needs as possible. And Medi-Cal planning is just one of it. The disclaimer, this is not legal advice. It's really for educational purposes. Every effort has been made to ensure the information is presented is accurate, but I've also had to choose between complete accuracy and keeping it clear enough and general enough. But my strong recommendation is that you don't just take what I have to say tonight and act upon it. I encourage you to seek legal counsel because little differences can make a huge difference. And just something that is relatively minor, you think, oh, I understood it, and you act on it, it can end up with creating significant negative issues. So what's the purpose of tonight's webinar? One, is that we're going to learn about the new Medi-Cal rules that are changing January 1st of 2026. You're going to understand who will be affected by that, see what we can do now while transfers are still penalty free, and know when and how to act before it's too late. Let's start with what is Medi-Cal. There's a lot of confusion out there. Medi-Cal is California's version of Medicaid for long-term nursing care. What happens is the federal government has a program called Medicaid. We in California have called it Medi-Cal. To the best of my knowledge, there's no such thing as Meta Ohio or Meta Nevada. But here in California, of course, we have to be different. And so we call our Medicaid program Medi-Cal. And it turns out that there's about 17 different types of Medi-Cal in California. But the one we're going to be focusing upon is Medi-Cal Medicaid for long-term nursing care. And that's the one that has the biggest changes that's occurring January 1st of 2026. Medi-Cal will pay for long-term nursing care if somebody's in a nursing home and there's certain circumstances. One, that the facility has to accept Medi-Cal, but two, you have to have, come January 1st, a certain limit on assets that you can have and qualify. Now, other people also get confused between Medicare and Medi-Cal. Medicare is that if you paid into Social Security, if you're at age 65, you qualify for Medicare. My wife and I have qualified for Medicare. Medi-Cal covers long-term care. Medicare does not. Now, some of you might say, well, wait a minute. I have an HMO or something. I've assigned my Medicare benefits. And they talk about nursing home. Well, with Medicare, if you've gone to a hospital, you've been in the hospital 3 days, and you get released to a skilled care facility, Medicare will pay for 20 days in a skilled nursing care, and they will partially pay for an additional 80 days. But at the end of 100 days, they pay nothing, and almost nobody lasts more than 20 days in a skilled nursing care facility, because if somebody's improving too quickly, they say you don't qualify because you don't need it, you're improving. If you're not improving quickly enough, you don't qualify because you're not making progress. And so most people, it's 20 days and they're going to be released to a different facility that Medicare would not cover. But no matter what, if you're looking for long-term care, Medicare is not the solution because it's limited by the 100th day rule, where Medi-Cal, which we're going to be talking predominantly about tonight, will cover as long as you need to be in a nursing care facility. The importance of Medi-Cal, the average cost here in California is running $13,656 per month. If you multiply that times 12, you're going to end up with about $163,000 per year. The vast majority of the people, myself included, don't have an extra $163,000 a year floating around to pay for our long-term care. So that results in that we can quickly deplete our life savings if we have to pay it out of pocket, or we don't have insurance that is basically nursing care insurance. This affects mostly the middle class and even some of the upper middle class, because again, at $13,656 a month, that's a significant amount of money that in order to pay that, most people don't have that much of income, so they end up paying it out of savings, and they're using up their savings that could be transferred to their family members later on. So who qualifies for long-term Medi-Cal? And there's a term up there called non-MAGI. I hear it pronounced as MAGI. non-Magi, and Medi-Cal is confusing in this area, that if a person is under the age of 65 and they have very limited income, then they qualify for what is called Magi Medi-Cal. And Magi Medi-Cal is, the word Magi stands for Modified Adjusted Gross Income. We're not going to be talking about Magi income because that's not what the focus and what the law change is. The law change is dealing with long-term care. And so anybody that's over the age of 65, blind or disabled, cannot use Magi, but are going to be using non-Magi to qualify. California residents needing skilled nursing care and must meet asset and medical needy for non-Magi rules. And so anybody for long-term nursing care is going to be using the non-Magi rules and not the modified asset gross income, adjusted gross income. So here's the limitations. Between 2024 and 2025, January 1st of 2024 and 2025, California, compared to the other states, went off the reservation and have basically said that there is absolutely no limit to how much assets a person can have and qualify for Medi-Cal. And so just to kind of drive this point home, theoretically, if Elon Musk was a resident of California, he qualifies for Medi-Cal from an asset point of view. Everybody on this Zoom call qualified for Medi-Cal during this time period. And so I would qualify from an asset point of view. Now, obviously, there still has to be a medical test, a medical needy part. But from an asset point of view, I qualify. Everybody in California qualified. Starting on January 1st of 2026, because of the budget deficit in California, California has said, wait a minute, we can't have everybody qualifying for Medi-Cal. And so what they're doing is they're going back to an earlier limitation. And to kind of give you the kind of the history to this, most people that have had like a loved one, a parent or something, go on to Medi-Cal, especially if they were like a single parent at that time. You'll remember that the maximum the person could have was only $2,000 and qualify. If we looked at June of 2022, a single person could have $2,000. And if a married couple was on Medi-Cal, they could have $3,000 worth of assets, of non-exempt assets. Well, in July of 2022, California changed the rules, and so that they said a single person, instead of having 2,000, could have 130,000 of non-exempt assets. And if they were a married couple with both on Medi-Cal, they could have not 3,000 but 195,000. And it turns out that if the situation, which is a lot of my clients fit into this situation, is that one person's in a long-term nursing care facility and the other person, the other spouse, or registered domestic partner, is living at home or out of a nursing care facility, they want the person that's living at home to have additional revenue, so they allow that person not to have be limited by the 195, but they, between the one in the nursing home and the one at living at home, they can have a total of $287,920. And so the spouse in the community can have, it turns out to be $157,920 plus the 130. That's how we get to the 287,000. And so, but those are assets that you can have that are exempt non-exempt assets and still qualify. So you can transfer Non-exempt assets made before December 31st, 2025 are not subject to any penalty. So let's just say that somebody comes in and they have $400,000 beyond the the asset limit. If they were to transfer that $400,000 in the before the end of this year, they can still qualify for Medi-Cal. If they transfer the 400,000 next year, they they arguably will be ineligible for Medi-Cal for the for a 30-month period, because California has a 30-month period, a look back period if you made gifts in excess of the exemption amount. So with that said, let's take a look at the background of exempt versus countable assets. And we're going to first start talking about exempt assets, because there's a lot of confusion here. If a person goes into a nursing home and on the application, they're asked, do you plan to return back to the home? And if you mark the box, yes, I do, even though every doctor in Southern California could say the person's never coming back, as long as you have the subjective intent to come back, the home is an exempt asset. Also, if you have a spouse living in the home is an exempt asset. There's some other situations where if you have a disabled child that's living in the home, that's an exempt asset. Also, if you had a child who moved into your home longer than 2 years ago for the purpose of helping you be able to stay at home longer, then that home will be an exempt asset. But generally, the primary residence is considered an exempt asset. Also, they allow for somebody that goes onto Medi-Cal to have one vehicle. The strategy there is that Medi-Cal wants to make sure that people have the ability to get to the doctors, etc. And so they allow for one vehicle. The fact that the person that's applying for Medi-Cal never had a driver's license, they can't drive, they still can have a car. They can have household goods, personal belongings, jewelry, etc. Retirement accounts, there's basically no limit to retirement accounts, but they must be in payout status. And what that means is that when a person has like an IRA, a 401k, a tax shelter annuity, that if they're over the age of 59 and a half, they can start taking out money based upon distributions over their life expectancy without paying a penalty. And now for some, it was 70 and a half. For people that are a little bit younger, it's 73, that you have to start taking out RMDs, required minimum distributions. Well, if you're taking out required minimum distributions, then your IRAs do not count as an asset. And you can have a burial plot, burial contract, burial plots, etc. So that allows for about a protection around 15,000, a little bit more. You can have term life insurance because it has no cash surrender value. And you can have cash surrender value. They allow a whopping $1,500. And they also allow for qualifying annuities. And we'll talk a little bit about that. So those are the exempt assets. So if you think about it, you can have your primary residence, and currently it's of any value. You can have one vehicle. You can have household goods and personal effects. You can have retirement accounts and payout status. You can have burial plots and burial contracts, and you can have a small life insurance term policy and some annuities. What are countable assets? Countable assets are cash, checking, savings, anything you'd have to have at a bank or whatever. Investments, stocks, bonds, mutual funds. If you have, let's say, a second home or a rental property, that would be an additional asset. Timeshare would be considered an additional asset. Vehicles, as other vehicles. Basically, everything someone owns other than an exempt asset is going to be countable. And here's the situation. What do they that the situation is that the come January 1st, Medi-Cal will impose a penalty, a look back period. Oh, let me go back for a moment. I think I may have skipped something. Okay, background. So with the deadline on January 1st, 2026, Medi-Cal will impose a 30-month look back period. And so if you transfer assets that are non-exempt assets after that date, then that's going to trigger a look back period. And how it's calculated out is that remember the average cost is $13,656. What will happen is that let's say that you transferred $50,000 of exempt assets. That would disqualify you for a period of 3 months. And the reason why is you would take 13,650, divide that by 50, and that would turn out to be 3 plus some remainder, and they always round down. So it'd be 3 months that you would be disqualified for. I know it sounds confusing, but the concept is that right now you can give away an unlimited amount of money and have it not be disqualifying. So transfers after the date may trigger disqualification or penalty period. Only transfers completed before December 31st, 2025 escape review. And so common misunderstandings, Medi-Cal will take my home. I talk to clients all the time about this, and one of the issues that comes up is that they will say, oh, I'll never qualify, and if I did, I'd lose everything because that's what happened to my grandmother, or that's what happened to my mom. Well, what happened is that remember, Medi-Cal is really Medicaid, and the federal government gives guidelines, and the guidelines say to the states, you must follow these federal guidelines. However, once you've complied with our federal guidelines, then you can decide how you want to implement it. And California has chosen to implement it in a way that California has chosen, and it's different than the other 49 states. Well, one of the federal guidelines is that if somebody's over the age of 55 and they receive any form of Medi-Cal, that when they pass away, their spouse passes away, and if they don't have a disabled dependent, that you must recover against the estate of the person that was receiving Medi-Cal after the age of 55. Well, Senate Bill 833 in 2017, California passed that bill, the Senate Bill 833, that says the word estate for Medi-Cal recovery purposes means probate estate. Well, the 40-some of us that are on this call all have living trust, or at least I sure hope that we do. And it turns out that that means because we have a living trust, we avoid probate. Therefore, Medi-Cal does not take your home, because any asset that avoids probate, Medi-Cal doesn't go after. And so the only assets that is the estate for the federal purposes by California rules is probate estate. And that's one of the reasons why you have a living trust, is to avoid that recovery. Another situation is, well, I don't think I'll do any planning right now. I'm going to wait until my loved one's health deteriorates. And my strong recommendation is that may mean that it's too late. Depending upon the size of assets, how we can transfer it or whatever, because unfortunately after January 1st, we're going to be looking at penalties when we're starting to transfer assets. And a lot of people have a belief that they just have too much to qualify. Truth be told, I have jokingly said for years that there's two types of people who qualify for Medi-Cal: those that are truly poor and those that have good attorneys. And it turns out that could I qualify a lot more people? And the answer is yes. But there's trade-offs. There's always pluses and minuses, etc. And yes, we could. I had somebody in my office that was talking about helping getting their mom qualified, and she had around $6 million in assets, etc. Could I get her qualified? The answer is yes. But as a practical matter, it probably is not. Uh, it's really not practical there, because there would be enough income, and there's always trade-offs. There's positives and negatives to everything we do. So with that, but to say I have too much, as a practical matter, yes, but keep in mind, IRAs don't count, your home doesn't count, and you're going to see some other assets that don't count. So we have some planning opportunities before December 31st of 2025. And this one here, this first one, is convert countable assets into exempt assets. So remember that there are certain assets that are countable, everything that's not exempt. Well, we can take some of those assets and convert those. And it turns out on this first one here, converting countable assets into exempt assets, not only do we have that opportunity to do it before December 31st, but we actually have the ability to do that even into next year. And we'll talk about how to do that in just a moment. We can create or fund an irrevocable Medi-Cal asset protection trust. And that's literally what probably the key to the planning for tonight's discussion is about, is taking assets that are countable assets and moving them and giving them away before the end of this year, where there's no penalty, no look back period, and that we can get the assets down to a level so that person can qualify for Medi-Cal without a penalty of waiting months because of making gifts. One of the things that we definitely want to make sure of is that your home is in your trust. And there's a couple of different ways of doing it. That probably the simplest way for the layperson to find out whether their home is in the trust or not is to look at their property tax statement. Their property tax statement, the one that we get every year, where we pay twice a year, that if it, for example, read James F. Roberts and nothing else after my name, that would be a strong indicator that it's not in the trust. If the property tax statement reads James F. Roberts TR, that TR stands for trust, and that would indicate that the home is in the trust. So every one of us should be looking at our property tax statement just to confirm, especially if we've refinanced our property, because a lot of times what happens is lenders will say, oh, we'll lower your rate, we'll refinance, take money out, do whatever needs to be done. But they say we need to take it out of the trust in order for this lender to loan money. Well, they're happy to take it out because that's how they get paid, is to get the loan to close. But then they fail to do the necessary step to put it back into the trust. And so especially if you've refinanced the property, you definitely want to make sure that it's in the trust. And looking at your tax bill is one way. I have a service that I pay, turns out to be several thousands of dollars a month, to look up deeds, but we can look up somebody's deed. So if you're not sure, reach out to us. We'll be happy to take a look at that. Coordinate with legal advisors now. That's part of the idea, is that part of the planning strategies is we want to make sure you are making wise decisions. And so you want to make sure, because little differences can make a big difference. So convert excess assets into exempt assets. So let's take a situation, and we'll just assume, for example, that there's a single woman, a mom, and She has a home, and her she owes $150,000 on her home, and that she has $200,000 in savings accounts. And that's pretty much IRAs. We're not talking about that. There's no limit there for this purposes. So to me, that's a no-brainer. What she would do is to take her $70,000 that's over the limit. Remember, she could have 130,000. So she was saying she has 200,000. And what she would do is pay down her mortgage by 70,000 because her home's an exempt asset. And that is an easy situation. And then now at that point, she has 130,000 of countable assets, and she qualifies for Medi-Cal. The other situation along that same vein would be to do repairs to the home. A lot of times that, as I've seen with my clients, as they get older, and especially when their health is failing, that they don't keep the home up as well as they used to. So that needs some painting, may need some carpeting, may need some roof repairs. Well, again, if our situation is that if a person is needing long-term care and they have more than 130,000, or if they're a married couple where it's only one spouse is in the facility and one spouse is not in the facility, they have more than $287,000, that they can't qualify for Medi-Cal come next year if they have more than that, until they spend those assets down or they have a penalty period. So doing repairs, doing them is just a good situation, because for one thing, when the time comes that potentially the children sell the home or whatever, if the home has been more recently painted, has a new roof on it, the home's going to be worth more than it would be, and it's more of a kind of a neglected stage. One of the things that clients can do is to purchase a car. Now, they only allow you to have one car, but I have in the past advised clients that don't have a driver's license, can't drive, never driven, to have the family members go out and buy like a classic car, because the rules say you can have a car. It doesn't say it has to be, under $5,000 or 30,000. And the strategy behind that one is that if you go out and you were to buy a brand new Lexus, the day you drive it off the lot, it's dropped in value and it just deteriorates. If you were to go out and buy maybe a 65 Mustang, the whole concept here is that the strategy would be that would keep its value and maybe even go up in value over time. And if after the person passed away, again, if we can avoid probate, which we can, then the children could sell the home, or excuse me, sell the car for more than what it was purchased for, and it's an asset that is appreciated. You can prepay funeral arrangements. It's not a huge number, but you can save about $15,000 by entering into a irrevocable burial contract. It has to be irrevocable. There's very specific things. You can purchase Medi-Cal qualified annuities, and that used to be a very common way to get people qualified. The situation is in California that the Medi-Cal qualified, it has to be based upon life expectancy. And for one thing, life expectancy is not necessarily what Jackson National Life or New York Life, the company. It has to be based upon Social Security actuarial tables, not Jackson National Life's tables. And so not all annuities offer based upon Social Security. There are some that qualify, some that don't. The reason why this is not a big solution is that the limitation is that if whatever part of the annuity that you don't use during your lifetime, when you pass away, it has to be paid to your estate. which means it gets paid back and pays off Medi-Cal. And what we're attempting to do is to have the assets go to your children, to your family members, and not to the state of California. So the annuity is not a big strategy, but it can be done. You can pay past bills. You anything that is an arm length where you get something of equal value, you can take care of. So, for example, if you were to retain our office to help you qualify for Medi-Cal and there was an expense involved, that is not part of the, we're not worried about a look back period or penalty. And the reason for that is because you got an exchange, fair market value exchange for it. And that's the limitation. What you can't do is gift things away, but you can convert it into an exempt assets and pay legitimate bills. Now, let's talk about the giveaway part. And that they're right for the next little less than 2 months, you can give away assets without a look back period of the 30-month look back period. And so one option is, let's say this mom has $200,000. So she's over the limit by 70,000. And if she just chose to give 35,000 to her son, $35,000 to her daughter, that would take it. Now we can't keep it where we just add their children's name to the account. You would have to take mom's name off title and the children's name would have to go on to that. Now, some people say, well, wait a minute, Mr. Roberts, I thought we can only give away 19,000 or some amount without some type of a gift tax penalty. Well, there's no gift tax owed until the number is substantially larger than 19,000. The amount that you can give away without paying any penalties turns out to be, without paying any gift tax, the amount turns out to be 13,990,000. And next year it's going up to 15 million. If you have 13,990,000, you're probably not going to be applying for Medi-Cal. So as a practical matter, very few people have more than 13,990,000. But if you did, you probably wouldn't need Medi-Cal to begin with. So the 19,000 and where that rule comes in is that the IRS says, you know what, normal people give away assets every year. For example, you give away money at Christmas, or you give away assets at birthdays or anniversaries or whatever. Well, they say if you give away less than a certain amount, the current amount being 19,000, you don't even need to report it. We don't care about it. As long as it's under $19,000, it has no impact. If you give away more than 19,000, so in this situation, mom's giving away 35,000 to each of her two kids, there's no gift tax owed because it's under 13,990,000, but you have to report that gift to have the IRS then subtract it off the 13,990,000. But again, very, very, very few people in the United States, it's less than 1/10 and 0.4% have an estate that's taxable at their passing. So mom could just give away the assets. That's simple, it's easy, but that's possibly not the best strategy. I truly think that rather than just giving the assets away, that you might want to consider setting up of a Medi-Cal asset protection trust. Because for one thing, if mom gives assets to a daughter and the daughter's involved in a car accident, gets sued, the money that she gave to the daughter is subject to her daughter's creditor claims. Where if we put it into an asset protection trust, we can protect it from daughter's creditor claims. And we can also structure it in the right circumstances so that if, let's say, the son is a spendthrift, that the money cannot be wasted by the son, but it's being protected. And so there are some strategies out there. And so I like the idea of setting up of it. It has to be irrevocable because it has to remove the money from mom's estate, but it's done in such a way that it's not just given to them outright and have them squander it. Now, with stock accounts, it creates additional problem. The additional problem comes from a capital gains tax issue. What happens is that when you buy an asset, that becomes your cost basis. So let's just say mom has stocks that her basis in the Chevron stocks are $10,000, and that the stocks today have grown in value and they're now worth 70,000. There's a law that says if a person owns an appreciated asset at their passing, that they do not have to recognize that they get a new stepped up in basis at their passing if they own an appreciated asset. That's true with real estate. It's true with stocks. It's basically not true with IRAs, not true with tax deferred annuities, but it's basically true with the vast majority of appreciated assets. So if mom has these stocks and she owns it until the time she passes away, the children would inherit it not with her $10,000 basis, but with whatever the values were at the time that she passed away. So if they were now worth 70,000, the children could inherit it 70,000 and pay no capital gains tax. If they receive it as a gift when they while mom is alive and just outright to them as a gift, their basis is $10,000. When they sell it for 70,000, they will report $60,000 worth of gain and turn over about 25% of that. So roughly they would turn over about $15,000 for the capital gains tax on that. A strategy behind avoiding that 15,000 capital gains tax is that what mom does is mom sets up a Medi-Cal asset protection trust. It has to be irrevocable again, removing the asset from mom's estate, but she retains the right in the legal document to say, I have the ability to pick among my family members what percentages I want to go to which beneficiaries. That ability to pick among her family members for tax purposes, for estate tax purposes, that is a sufficient control that it causes the asset to be included in her estate for estate tax purposes. That 13,990,000 exempted, so there'd be no estate tax, but that causes it to get a stepped up in basis. And then what happens is that but it's not included in her estate for Medi-Cal purposes. So if you got lost on that, don't worry about it. Just be aware that there's a way of doing it so that we can move it out of the estate for Medi-Cal purposes, but we don't lose the stepped up in basis at mom's passing. And that brings us to the next one, and that's the second home. It is amazing that there's a lot of laws out there that people just are not aware of. But in the past, having a second home for most of the situation is really the thing that prevented people from qualifying for Medi-Cal. But in this last 2-year time period, January of 2024 through December of 2025, you could have two homes, you could have multiple apartment complexes, etc. And one of the challenges is that if you are in this situation where you have a family member or yourself is in a nursing home and you qualified in the last 2 years, when the renewal comes up, and they renew every year, and the month that you were accepted is the month that you are going to be notified that you have to disclose your assets. If you now have assets that are above the 130,000 or the $287,000 limit, you lose your Medi-Cal unless you can convert those assets. And if it's in 2026, The only thing you can do is to try to convert them from exempt, I mean, from countable into an exempt asset, paying down the mortgage, fixing up the home or whatever. You just can't give it away because the giving away is going to trigger that look back period. So what happens is that the if you had a second property and we were trying to qualify you for Medi-Cal, one of the things that is available today is California defines the word fair market value on real estate in a very unusual way. The definition of fair market value for almost all purposes is what a willing buyer will pay a willing seller with neither one under a compulsion to sell or to buy. But a lot of my clients have bought properties back in the 70s, the 60s, the early 80s, and for Medi-Cal purposes, they do not use what a willing buyer would pay a willing seller, that fair market value. They use the assessed value for property taxes. Now, it's even better than that. If you have a licensed appraiser that appraises it for less than the assessed value, Medi-Cal will use the licensed appraiser's value. But almost everything in California is a practical matter, is that what this means is that let's say that you had a property that you bought for $60,000 back in the 70s. And because of Prop 13, that it gets adjusted 2% per year, the assessed value, if you look at your property tax statement, what they say is the assessed value that you're paying the taxes on is not the $1 million that it's worth today, but rather the $100,000. Now, all of a sudden, because the assessed value is under the 130,000, even a single person could now have a second home, and they could use that 100,000 as part of the 130,000. They'd be able to keep another $30,000 of cash, but they could give away the other cash or whatever and qualify. For a married couple, they can have $287,000 of assessed value property and qualify. So there's some planning strategies. Again, if you don't follow it, the whole idea tonight is not just to give you, exactly what you need to do, but it's to to at least expose you to some options that are available. And as we're going to talk in a few minutes, who should be looking going forward and who can say, you know what, I'm okay for right now. I don't think I need to do anything. And so that is the first option. The benefit of doing that option of doing the assessed value rather than and kind of keeping it the property is there's no negative ramifications to it. We don't have to worry about capital gains tax because it's still an asset at your passing. As long as we have it in a trust, it'll avoid probate. And there's no property tax, no reassessment at this time because it's still being owned by the same owners. That brings us to the second option with regards to a second home, and that is you may want to transfer the home into a Medi-Cal asset protection trust. So if we can't get the assessed value is higher than these limits here of 130 or the 287, then you can transfer that home in the next 2 months into a Medi-Cal asset protection trust and not have it be disqualifying you from Medi-Cal. However, again, we would put in that provision that would allow the grantor, the person transferring the assets. Give me a second. It jumped ahead. The person who is transferring the assets can retain the right to appoint among their beneficiaries as to who gets what. That allows it to be included so we get the capital gains tax benefit. But the major drawback to this is that there will be an increase in property taxes because the grantor mom in this situation is no longer the owner an irrevocable trust is the owner, not for her benefit. That's one of the situations. It's for the benefit of her children. And therefore, there would be an increase in property taxes. That's not always terrible because if they plan to keep the home anyway, the second property, that they're going to have an increase in property taxes when mom passes away. But by getting rid of the home, that's going to potentially be saving the family maybe $10,000, $13,000 a month in Medi-Cal protection. So we have to kind of balance that against the increase in property taxes, but generally it's a much better to be able to have Medi-Cal pay for the long-term care. So it's again, it's a planning strategy that's available. Uh, so what's the next step? What should we be looking for? So let me kind of summarize before I go too much further. Medi-Cal is very technical and it does require little differences, making a huge difference. And just because somebody had something happen to them does not mean that that's going to be your situation. It turns out that there's something like 17 different Medi-Cals in California. The one that we're predominantly focusing upon is long-term nursing care. So, for example, remember the non-MAGI Medi-Cal, one of the things was 65. Well, those are different rules if you're just going on to Medi-Cal if you're over the age of 65 than if you're going on to Medi-Cal for long-term nursing care. And so it turns out that you or your spouse are already on Medi-Cal nursing facility. If you have a loved one on Medi-Cal nursing facility, my strong recommendation would be to schedule an appointment with us or with legal counsel, but with us to have it be looked at. You know, look to see what your situation is just to make sure that you're under the limits. Because, for example, we know that people between between January 1st of 2024 and December 31st of 2025 can qualify with unlimited amount. And so those people would definitely be somebody that wouldn't want to look at because they just had different rules. But let's go back for a moment and say, wait a minute, I have a loved one that went into a nursing home maybe in 2022, 2021, and they qualified. Now, they probably won't have any problem now qualifying. And the answer is yes, they could. For example, remember that they allow for the well spouse to have more money because there was a community spouse. They want them to have assets to live off of, etc. Well, if that well spouse passed away and left that money going to the Medi-Cal, the spouse that's in the nursing home, now all of a sudden, instead of having 130,000, they have 200 and we'll say roughly $280,000. Guess what? They're now no longer qualified. So we need to look really at anybody that's in a nursing home. We just want to make sure that is clearly, if you have a loved one that's in a nursing home, we should be talking just to make sure and that they're under the limit. The other situation is the people who are really should be looking at this thing is that we know long time that we do sometimes with our family members, we don't want to admit to it, but we know when somebody is failing. My mom suffered from Alzheimer's for about 8 years, and I could see a progression going down. You could see that. I I chose to privately pay for my mom. I did not qualify her for Medi-Cal. Could I have qualified her for Medi-Cal? Yes, but we had enough money. There was enough income coming in that we really were not using up my mom's assets. And it just gave us more options. But if you have a loved one that you can see that they are failing and that you can tell that probably in the near future they may need to go into a long-term nursing care, this would be the type of person that we should be talking to right now because there are some planning opportunities that are worth at least exploring. The next one is that if you want to make sure that you're protecting your home, your savings. Again, to me, it's really the first two, but there are strategies that people can do to protect their home, their life savings from recovery. We want to make sure that it avoids probate, and that's somebody, and you're just not sure whether your assets qualify. My recommendation would be you would schedule an appointment within the next 2 weeks. And the reason why I'm suggesting the next 2 weeks is, yes, we have the ability to uh, uh, transfer and gift assets without a penalty period until the end of the year. But a lot of the strategies are going to take some time. If we have to pay down a mortgage, if we have to set up a Medi-Cal asset protection trust, there's things that we need to do that we can require some time. And so we can't wait till December 31st to start our planning. We need to have everything in place before then. So then, so if you say, yes, I want to take advantage of doing a consultation on Medi-Cal planning, I am strongly encouraging you not just to show up and say, well, we may have some assets here. You're going to need to do some homework. And the homework that you're going to need to do is to bring in your bank statements, investment statements, stocks, situation. You need to bring in your property tax statements and ideally your deed to your home. But if you don't have the deed, I can look that one up. But we definitely need the property tax statements and we need the deeds. We need your most recent tax returns because that's what they're going to be looking at. This is what Medi-Cal looks at. And so what we're looking to do is to kind of pretend that we were having you apply for Medi-Cal and see how far off you are. And so we want to look at your most recent tax. We want to look at life insurance, any annuity statements, and then we would need to look at your income sources, your Social Security, pensions, etc., because it's we need to take a look at all of it. One of the questions that comes up with this long-term nursing care is, for qualification purposes, income doesn't enter into it. However, there are limits to how much how much income you can have before you have to pay a share of cost. And the rules are very technical. We could spend another hour explaining it. And by that time, I know if anybody was still awake, you wouldn't be. But the concept is that again, we do some planning to try to make sure that we keep as much of the income for the family and not going to Medi-Cal. So income, those were the things to bring in. How can we help? Well, we've been helping families for about 44 years, protecting their assets from Medi-Cal. The strategy is not one size fits all. I've literally had thousands of families that I've helped, and every time it's a different situation. And the peace of mind of knowing your care and legacies are secure. The key takeaways, here's what you should be aware of. The asset limits, anything above $130,000 of countable assets after January 1st for a single person, comes back into effect. If both parties are on Medi-Cal, it's $195,000. If one's party's on Medi-Cal and long-term care and the other one's in the community, it's $287,000. Those are going to be the new limits going forward. If we transfer assets of any amount before December 31st, 2025, we could qualify. So theoretically, I'm not saying it makes sense, but I'm saying theoretically, if Elon Musk, I believe he's not married at the time, if he's not married, he could transfer all of his wealth other than the $130,000 and one home, one car, and qualify for Medi-Cal. That's not the plan, not the typical situation, but it is a situation that there is definitely a planning opportunity that's available right now. Act now, review, and reposition assets. For some people, this can be absolutely critical, and that we ask that you schedule your consultation within 2 weeks. What we're saying, if you want to go to the next step, call to schedule your appointment, bring your document checklist with you. The limit appointments through December 2025. It's really, as I mentioned, I believe earlier, I have reached out to people that are in a nursing home facility because those people are literally, they don't have a choice. If they're over the 130,000, if they're single, come next year, they will not be qualified for Medi-Cal without planning. And so I've reached out to them, and there are definitely people that are in need. And what we're doing is we're offering an opportunity to sit down with families or with you and review your situation. I'm charging $575 for that hour review. There's going to be some time I'll spend in advance or whatever, but that would give us the opportunity to look and see what needs to be done. Now, who would not want to take advantage of that? If you say, Jim, there's, I have sufficient income that I don't need to worry about Medi-Cal, that I can pay for it privately, or I have a long-term nursing care policies that will take care of it. My strong recommendation is we don't want to waste your money or our time on something like that. If you said, Jim, that I, you know, I don't see that based upon my health, I just don't think that I'm going to need it for 10 years. I really don't think we're going to do a lot of planning right now, because everything we would be doing is giving up some control. And personally, just share on a personal basis, I'm 70, I'm almost 71 years of age. My health, I consider myself to be phenomenally healthy. I hope everybody understands that I gave up my dancing lessons today to have this Zoom call, but it is, and hopefully you understand that's a light call, but it is a situation that I am very active, and I don't see that I'm going to be in a nursing home in the next couple of years. But people who are at a stage where they can see that that's a possibility, I really do think that we might just want to meet, check, and find out whether or not it's there. I leave it up to you. It's your call, but part of why I'm charging a fee for coming to it is because that I want to make sure that with the amount of people that I have that has potentially wanting to have these meetings, that the people that show up are serious about it. At least they're willing to invest $575 to verify that. And should it turn out that there is something else that we need to do a Medi-Cal asset protection trust, transfer a deed, do something, then we would apply the 575 towards the cost of going forward. So that's what we would be doing. The next part of it is going to be opening up for questions and answering. And I just checked a moment ago, and there was over 40 people still on the Zoom call. And so I suspect that there's going to be a lot of questions. And I know it's complicated, but what I'm going to try to do is open it up to questions. If somebody has a question, does anybody, and Diana, if you don't mind, why don't you step on into my office? I have one of my staff members uh, here, and she's much more so that I can find out if there's somebody that actually has a question. Is there a way to, um, I see a question in the notes, is a nursing home the same as memory care? And the answer is yes, there are Medi-Cal qualified memory care facilities. There are private paid, but there are. And another question was about Roth accounts. How were they treated? Bad news. You have to treat the Roth somehow as a asset as part of that 130,000, or you have to 130 or the 287,000, because Roth do not have a required minimum distribution. We have to figure out another way to exempt those. When should my parents apply for Medi-Cal? You can apply for Medi-Cal even if you don't need it, if you can qualify. And so there are people right now that are applying for it just to get onto it so that they have that planning strategy. Uh, uh, and so that you can apply for it, or you wait until you go to a nursing care facility. The other situation is that if you have a question, if you would go ahead and raise your hand, and let's just, I'm going to have my daughter. Remember, I said I have an employee here. My daughter is now working for me. So I have, okay, okay, Sonia. Go ahead, Sonia, can you hear me okay? You need to unmute. And do you have a question for me, Sonia?
Yes, Mr. Roberts, thank you. Can you say again, what does it mean for retirement assets to be in payout status? Is that,
Sure.
oh, okay, thank you.
Yeah, what it is if you're over 59 and a half, you have to be taking out basically a minimum amount every month, and it's kind of like a required minimum distribution. So if you're over 70 and a half or 73 now for the younger people, RMDs, that would be the required minimum distribution, and that does not count as an asset. And so you just need to be taking out an amount every month. The problem with Roth IRA, there is no RMD, and so they basically say that it doesn't count. Are you worried that, Sonia, you're not yet 70 years of age, or are you past 70 years? And I apologize, not a very nice question to ask, but uh, are you in a situation where you're under the, before you have to start taking out RMDs?
That is correct. We're under the age where we have to take out RMDs, but we are taking out a monthly amount out of the retirement assets.
And that we can get you qualified for that. That has been in the past, they've allowed that. And you can do it if you're over 59 and a half without paying any penalties.
Thank you.
Okay. And there's, we're going to look for somebody else that raised their hand. So hold on for a second. If you have a question, raise your hand and then we can unmute you, or you can post it in a question in the chat if you want, either one. Do you have any other questions? We're good. Let's take a look to see if there's any additional questions in the chat. I think we may have one. Okay. Let's go back to, give me a second. Okay. this point, both my wife and I are healthy and don't foresee that we need long-term nursing care in the next couple of years. Um, Care in the next couple of years. So do we need to do anything? I, I wish I had an absolute crystal ball to tell you the right answer, but my personal opinion is that almost anything that we do to get somebody qualified, there's going to be some positives and some negatives. One of the major negatives is that if you have over that taxable limit, over the uh, exempt limit, you're going to be giving up control. And that means you're giving it to somebody else, your children. If you set up a trust, we can name some other trustees that you trust to set it up and be in control of it. So I, I'm going to share with you as for me, I'm not giving you advice on this. My wife and I are not giving our assets away at this stage to our children. Uh, because yeah, and I trust my children. It's just that it's that first of all, that as a practical matter, that the the laws probably going to change in 5 years type of a situation. And so, but if somebody is likely to go to a nursing home, I would definitely think that you would want to consider that. Can the funds in an irrevocable Medi-Cal asset trust be used for the person's living expenses who manages the trust? The answer is you can set it up any way you want. And so, yes, the answer could be used. Um, the the situation is that I have had some clients set up type of a trust where the children can get the income, but it's always just kind of kept as a reserve just in case that mom or dad needed the money in the future. Uh, but it has to be, kind of just that a tacit arrangement, nothing that's specified because again, it has to be out of your estate. Can I give my rental to anyone? And the answer is yes. If you do, that will, if it's anybody other than a spouse, uh, it's going to increase property taxes and uh, they will get it with your cost basis, not with the new basis. But you could give a rental property before the end of this year to somebody and you could qualify without the 30-month look back period on that asset. If my parents apply for Medi-Cal and qualify, are they eligible for IHSS, and that's in-home service? I'm going to share with you that the answer is that yes, they would be eligible for that. Uh, my knowledge is not particularly knowledgeable in this area, but very few of my clients have actually been able to hit the requirements that allows for in-home support services. And so, but yes, you would still be able to qualify. You can I think the question was a follow-up to anyone, not family. And the answer is yes. You can give away during your lifetime, you can give to anybody that you want to 13,990,000. And to make light of something, if you want, you could give that to your attorney, James F. Roberts. And so I just wanted to make sure you keep that light. But it is a situation that you can give it to anybody without, and it would still qualify. Are they eligible for in-home support services? Right. My unmarried sister is on Medi-Cal now. She is age 60 and takes regular monthly withdrawals from a traditional IRA that has more than 130,000 in it. Is this an exempt asset? Oh, You got an interesting question. I'm going to think about it for a moment. First of all, she's past the age of 55. So Medi-Cal, I believe, requires that when she passes away for expenses that are occurred after the age of 55, she would, they're going to come after her assets. Uh, However, if she has an IRA with a beneficiary that's not her estate, then what will happen is that because it avoids probate, Senate Bill 833 exempts that from Medi-Cal recovery. So the answer would be she would not be subject to, she could have it go to a family member without it being recovered by Medi-Cal. Uh, my mom is incapacitated. Can I set up a Medi-Cal trust as a trustee of her present trust? You know, one of the things that's a good question uh, that we have to look at because we need to look at the powers of attorneys. We would need to look at the language of the trust to see if we can somehow get the authority to set up an asset protection trust type of a situation. There's typically language that says that we can shift assets, make gifts, etc., to get somebody qualified. So the answer may be that we have that authority. We'd need to take a look at your mom's trust and her specific documentation, but there is a potential chance. And Sonia, you're welcome. She was just saying thank you. I hope that you got something of use out of that. I'm going to go back and okay. I look forward to meeting with you, Doug. And uh, let's take a look at, is there anybody else? Okay, hold on. Jeffrey, you want to, is that the one?
Yes, thank
Hi.
you. Hi. Mother is 96.
Mm-hmm.
We have we started out with the family trust with my dad and my mom. Dad passed away 10 years ago. So mother is the trustee, if I understand it correctly. And then my sister and I become the next step should something happen to mother. But if she might be needing, right now she's totally independent in her house, all by herself. Everything's awesome. But should she need care because she's 96 in the next year or two, should we go ahead and make an appointment to start this MAPT? Because as I understand it now, we won't be going to probate because the family trust has taken care of all of that, but she has more than 130,000, so we would have to pay for care if I follow this correctly.
Let
I'm
me,
sorry.
you,
I'm
you,
sorry.
I, you made a lot of sense. Let me just, and I don't want you to disclose the situation, but if we are talking $3-4 million above the 130,000,
Uh-huh.
then my recommendation would be, I think you're very comfortable not uh, uh, scheduling an appointment. If we're talking maybe 100,000 or so, my recommendation would be that yours would be something that I think would be worth having that meeting just because we have the meeting doesn't mean we're applying for Medi-Cal. It's really looking at the specific situation to see how far or how much we would have to move things around. And then we would still make a decision of
Okay.
the cost benefit. And could we do anything next year, even after the law changes, that would make it if we had to, so there's different situations that can be done. But right now, uh, that uh, it really depends on, if somebody has, multi-millions of dollars, probably at 96, I'm not sure that I would be doing a whole lot. But if somebody
Okay.
had a couple $100,000, Yeah, because if a 1 year in a nursing home is $163,000,
Correct.
it doesn't take very much to go through a couple $100,000.
Yes.
Does that help
Okay.
answer your
It,
question at
it
all?
it does. I'm in Canada, and so I don't understand what Medi-Cal is or any of that, but I will be down there in a couple weeks.
Okay,
So I will call the office. Thank you so much
perfect.
for your time.
Oh, you're more than welcome. Hope that helped you. And I just got back from Canada. I just was up in Montreal uh, uh, and caught a cruise ship out of Quebec
Oh,
and
how
ended up at
nice.
Fort Lauderdale. So I today's my first day back at work, so you can see how hard I'm working. Uh, so
Thank you.
post-colonial memory care, she owns a home and in the trust and has only 10,000. House is currently rented and funding Social Security payment. Would it be beneficial to get her on Medi-Cal and a medical facility? Are I would definitely think this would be one, Tim, to uh that we should talk because uh it really depends on mom's income because she has the currently the rental and funding Social Security. Yeah, I would definitely think that it would be worth talking about and looking at that one. That would definitely be one that I think would be a situation that it would be very prudent to come in and talk on that one. So uh, you're welcome, Tim. Um, and my daughter's going to check one more time to see if we have any other calls. And if not, we're going to be wrapping it up. You know what? I just I want to acknowledge each and every one of you for staying on through this. Um, it's a situation that I wish I could make it easier to understand and so forth, but it is so complicated that it really takes somebody that understands it to follow it. And it's the government for it for you. But it is a situation that there really is some planning opportunities right now in the next roughly 2 months that we're not going to have next year. And that's the reason why I've reached out. I would just share with you that if you hopefully you found this meeting useful. Um, I I remember I just said I got back from Canada. I spent a lot of time on my vacation getting ready for today's meeting, and but I was happy to do it because the more that I know, the more that I'm in a position to be able to help people. And the thing that I would ask is that if you're not sure or whatever, if you feel like it's worth investing $575 to get your answers, we're more than willing to try to accommodate you, assuming that we can find a time slot that will work for us. Also, if you found something useful out of this, the best thing you could do to help me is that I'm on a, I just recently hired a new marketing company and they have indicated how critical it is for future success to get Google reviews. And so if you felt that you've been treated well by our office, if you feel that we've treated you well, that we would love to have you give us a Google review. Because apparently, according to my marketing person, Google is actually the way that people find out. And I would like to believe that we try our best to provide quality information and treat people as best as we can. And that hopefully that by you giving us a review, that's going to cause some people in the future to be able to have something to judge against compared to another law firm. So with that said, I think I'm going to wrap it up. I look forward to seeing some of you in the office. And thank you for sticking around. And I hope everybody has a wonderful day. You take care. Thanks. Bye bye.